Hello, everyone. Thank you for joining us today for this webinar on the rights of incarcerated victims of crime. The webinar today is focused on providing a deeper look at the legal rights that are provided under the Victim Rights Act in Colorado and the Prison Rape Elimination Act, and a comparative analysis of those different rights. This webinar is part of a larger project that Rocky Mountain Victim Law Center has had the privilege of working on with the Colorado Coalition Against Sexual Assault. CICASA has been funded to do a larger project looking specifically into PREA rights and the rights and support services and a myriad of other things, education related to incarcerated victims of crime. As part of that project, CICASA asked Rocky Mountain Victim Law Center to do a deep dive into some of the legal differences between the Victim Rights Act and PREA and identify where those laws line up with each other, where there are some gaps, and make some recommendations for improvements. So that's really what the webinar today is going to be focused on. I want to start and give you just a little bit of an overview of who we are and who I am. So my name is Kazi Houston. I'm the legal director at Rocky Mountain Victim Law Center. RMVLC is a nonprofit law firm in Colorado. We are based in Denver but provide services across the state of Colorado to address the legal needs of victims of crime. We do that through 3 different programs. The first program is the one we were founded on that is focused specifically on advocating for the rights of victims in criminal cases under the Colorado Victim Rights Act. So we actually act as victim counsel for victims of crime in criminal cases, and then provide a whole lot of other technical assistance and support for victims who are navigating the criminal justice process. The second program that we have at RMVLC is a Title IX program that is similar to the VRA program in that it's also providing legal services to victims of crime, but instead it's focusing on the legal needs of survivors of gender-based violence in educational settings. So where Title IX protections would apply, one of our programs is focused specifically on providing legal services in that context. Our third program is the Legal Information Network of Colorado, or LINK program. LINK is a collaborative program that's focused very much on providing comprehensive legal information to victims of crime on all the different legal issues that might come up after victimization, such as housing questions, employment, family law questions, protection orders, and providing information referrals and some very limited direct representation related to connecting people to legal support for those types of issues. Lastly, Rocky Mountain Victim Law Center provides an extensive amount of training and technical assistance across the state to service providers. That includes things like this webinar, researching issues, providing sample motions, consulting on cases, things like that. So feel free to reach out to us after this webinar today if you ever need anything related to any of those programs. A little bit of an overview about the plan for today is that I'm going to do a fairly deep dive into some of the legal provisions under the Victim Rights Act and the Prison Rape Elimination Act. We're going to look specifically at some of the key VRA rights related to fairness, dignity, and respect, privacy, notice and right to be present, the right to be heard, and safety and protection rights, and look at how they are different or vary or have different applications and purposes in the VRA and PREA. After we go through each of those different sections, I'm going to talk about some of the areas of harmony and some of the gaps in the law that we saw doing this analysis of the different laws, and then talk about some of the recommendations that we are making as a result of the analysis we've done. Strictly as a reference point, these are the statutory provisions that are most relevant to talking about the Victim Rights Act in Colorado, also the Federal Victim Rights Act, which is similar, and then PREA and where you can find that in statute. So if you want to go look up any of the statutes and actually read the laws around each of these things, that is the place to do it. So we're going to start today talking about the purpose of each of these laws and how those are different. So I'll start by talking about the Victim Rights Act. In Colorado, the Victim Rights Act became enacted in law in 1993. It became a constitutional amendment in 1992 and was voted on by more than 80% of Colorado voters who decided that this was a value we wanted integrated into our state constitution. There was then a whole set of legislation that followed to enable that actual amendment to come into effect that really designated the specific rights for crime victims in the criminal justice process. So it's a fairly new area of law and fairly new in the context of broader legal issues and legal rights, but it is certainly something that's ingrained in the criminal justice system in Colorado and has been since 1993. The VRA was designed explicitly to improve victim participation in the criminal justice process. And the very first section of the VRA actually talks about it's vitally important for victims of crime to participate in the process for it to work. So to make sure the criminal justice system is fair and efficient and effective and working well, it's acknowledging that they need to have a way for victims to participate in that process. So the VRA was designed to enhance the participation of crime victims in criminal cases and then also protect their rights in that process. The VRA creates explicit new rights that apply to victims of crime that didn't exist before. And then some of the fundamental principles that we're going to talk a little bit more about today under the VRA is the right to be treated with fairness, dignity, and respect, and the right to be informed, present, and heard through all critical stages of a criminal case. We'll go in a bit more to what that means, but those are the key purposes, key provisions, and the focus of the VRA. PREA, on the other hand, the Prison Rape Elimination Act, is also very new. It started in 2003. It's a federal statute and federal rules that are designed with the specific goal of trying to prevent rape and sexual abuse of people who are incarcerated. So really that prevention factor of sex assault and sex abuse, and really focused less on what happens after a crime has been committed and on making sure that there's in facilities that are safe for people who are incarcerated so that they are not subject to victimization. PREA builds directly on the 8th Amendment right under the US Constitution against cruel and unusual punishment, and is built directly on that principle that just because someone has committed a crime doesn't mean that part of their punishment should also be to experience victimization. So out of that mindset and philosophy came PREA, which is a whole set of prevention measures, education and notice measures, screening processes that we'll talk about, all designed to prevent a crime from occurring, and then a very robust set of data collection to get a feel for if those measures are being implemented, if they're actually resulting in a reduction of crime, and what that looks like as PREA is implemented. So unlike the VRA, which created specific new rights all along the criminal justice process, PREA is really focused on crime prevention and implementing the right to being in a safe correctional environment, and then collecting data on that so that continued things can be done to prevent more crimes from occurring while people are in custody. Similarly, there's pretty vast differences between the scope of the VRA and PREA. As I mentioned a little bit, PREA is very focused on prevention, so it applies whether or not a crime has occurred. It is also specific only to sexual abuse and sexual assault. And the VRA, on the other hand, protects victims of crime after a crime has occurred. So instead of having that prevention lens, the Victim Rights Act is focused on all the rights that attach to a victim as soon as a crime is reported to law enforcement by anyone. At that point, someone who's a named victim in a criminal case, if it's a specific crime that's covered under the Victim Rights Act, the Victim Rights Act then applies. PREA is much more narrow. It only protects people who are incarcerated, which includes, you see the list on here, all federal, state, and local prisons, jails, police lockups, private facilities, community settings such as residential facilities, including juvenile detention, community corrections, things like that all fall under PREA. And one of the important things to know is that both of VRA and PREA create obligations for government actors to do certain things to ensure that in the case of the VRA, people are treated with fairness, dignity, and respect and provided certain rights. And in PREA that there's obligations around reporting, data collecting, prevention measures, things like that. So there is some shared similarity in the scope and the purpose of the VRA and PREA in terms of mandating and making requirements for government actors around the protection and treatment of victims of crime. So as we look into the specific rights, we're going to go through the key rights that are present in active and critical to the Victim Rights Act, and then look at that as a starting point to comparing what that same right looks like in PREA, if it applies, and if it's something that might be a gap, or if there's things that are in PREA that could enhance the Victim Rights Act also. So starting with the essential fundamental right of the Victim Rights Act to be treated with fairness, dignity, and respect. Under the Victim Rights Act, the very, very first provision says that all crime victims have the right to be treated with fairness, dignity, and respect, and to be free of harassment and intimidation throughout the criminal justice process. There's not a clear set legal definition for fairness, dignity, and respect. It's a much more just subjective framing of, acknowledging that a victim has a role in a case and in the criminal justice process, acknowledging that the crime that occurred affects them directly, and then treating them with the respect and dignity that stems from that acknowledgement and recognition that it's not just a legal process. So it's a very subjective standard. There is not, however, any parallel right to that under PREA. So PREA doesn't have any language that talks at all about treating people with fairness, dignity, or respect, or anything specific around how people should be treated, or that kind of subjective factor, beyond the focus on making sure that people are able to have the basic human right to be free from sexual violence being committed against them. So there is some inherent recognition that people should be treated fairly with dignity and respect in terms of not being subject to victimization, but not in this broader way the VRA talks about it in terms of communication, notification, participation, things like that. The VRA also is, again, focused on the treatment of crime victims after a crime occurs, but there's nothing that is done to try and prevent crime. So that is a gap where PREA is focusing much more specifically on prevention of crime and that basic right to be free from having crimes committed against you. That piece is missing from the VRA. One of the big fundamental rights under the Victim Rights Act is related to the right of privacy. There's extensive rights under the Victim Rights Act related to privacy, including things like having the right to be heard about a subpoena for a victim's own privileged records. So if there's a request for records from an educational facility, medical, mental health, in Colorado, domestic violence and sex assault advocates have privilege. So community-based advocates that have privilege, also records related to that, would be considered to be part of this right, that if a subpoena is issued for any of those records, the victim of the crime actually has the right to address the court on that, say if they've given permission for those records to be part of the case, and actually have a say in what information about themselves becomes part of an investigation or a case. Some other key VRA rights related to privacy are specific things around limiting the release of identifying information, especially locating information. So redacting social security numbers, the ability to provide alternate addresses or no address, the ability to not have to testify about your address, current source of employment, things like that, specifically to maintain some of the privacy of victims of crime. PREA doesn't have many of those rights, and some of them for very, very apparent reasons. When someone is incarcerated, they often lose a lot of their fundamental rights just from a safety and management perspective. And PREA does not restore any of those rights to pre-incarceration levels. And it also offers limited protection of information through an investigation. So there's no provisions that say locating information should be redacted or anything should be kept out of a report. And there's no right to be heard if there's a request for information about someone's privileged records. So for example, if someone sought medical or mental health treatment within a facility and part of the investigation involved seeking out those records, there would be no right, no parallel right as under the VRA for someone to challenge whether or not those records should be able to be part of that investigation or any case that stems out of that. There's also under PREA very limited rights to accessing support services in as confidential a manner as possible. So this doesn't provide broad access or any kind of right to always have confidential services, but just a means to get support services that are, again, as confidential as possible. So it doesn't require that it be confidential, but it does require if something isn't confidential that the inmate in person in custody is informed that if you call this hotline, your call's recorded or things like that, so that they know what the level of confidentiality is. One other thing that's important is we'll talk a little bit later about safety rights. There is a specific right under PREA and specific rules protecting against retaliation after a report is made. And there's multiple factors that are addressed in terms of things facility staff should look at to screen for retaliation or try and prevent retaliation. Confidentiality is not addressed as one of the means of preventing retaliation. So there's really no inherent built-in privacy protections in PREA that allows someone who's been victimized to ensure that that report isn't widely shared or that it's not something, any of their location information or other identifying information is kept away from other people. There are some general expectations, if you look at bullet 2 under PREA here, about limited protection of information about an investigation, but there's extensive exceptions. So for treatment, investigation, or anything related to security or management, that's given as a reason why the protection of information doesn't need to be maintained. So it's much more of a vulnerable position for a victim who's incarcerated in a facility to not know that if they make a report, where that report's going to go, who might see it, and there's a lot of exceptions for when that information could be shared. When we turn now to the next big right under the Victim Rights Act, the right to notice and presence, so the right to be actually present throughout the criminal justice process, the right to notice about what's going on through the criminal justice process, are very fundamental to the Victim Rights Act. And they're both safety rights that we'll talk about later, but also just general participation obligations and rights. So under the Victim Rights Act, there are extensive requirements for notification all along the criminal justice process, and extending from location of inmates who are offenders, and if people have been released from custody, if they've been moved to different facilities, and then also just notification about different events through the process. So when charges are filed against someone, consultation before a plea offer is extended, notice of hearings, things like that. And there's also a right to be present at all critical stages of the criminal justice process. So the Victim Rights Act specifies a broad range of phases of the criminal justice process where victims not only have the right to know what's happening, they have the right to actually be present at hearings and to be a much larger part of the actual process. Under PREA, it's very different. So there is a right to make a report, and there is a right at the end of an investigation to be told whether that report was substantiated, unsubstantiated, or unfounded. And that's about it. So anything that happens along the way, there's no legal obligations under PREA for the facility to inform a victim inmate around what's happened, what's the process of things, what's happening in the investigation, are there any proceedings or hearings, or is there anything happening event-wise. There's no critical stages that there's rights that are attached to, things like that. So to this general, you have the right to make the report, and then at the end you have the right to know not even just the facts of what the basis of the decision was on, but just whether it was substantiated, unsubstantiated, or unfounded. If it is not unfounded and it's found to be a valid report, there is some additional notice regarding the offending person, so the perpetrating party. If it's a staff member, if they have been fired, transferred to another facility or section within the same facility, charged with a crime separate from the administrative PREA process, or convicted of a crime, there's a right to give notice to that of the victim inmate who's incarcerated. And similarly, if an offending inmate is charged or convicted of a crime, there is an obligation under PREA to make attempts to inform the victim of that fact, but nothing related to their location or any notifications related to whether or not they've been transferred or where they're located, things like that. The next right we're going to talk about is the right to be heard under the Victim Rights Act. The right to be heard in the VRA allows victims of crime to have direct access to the court and give actual statements on things in several different places. So one is around plea hearings, sentencing, giving victim impact statements. We talked before about the right to be heard on subpoenas for someone's own privileged records. There's also some rights to be heard around modifications of protection orders, some rights related to some bond proceedings and changes in bond, not initial settings, and petitions for expungement of juvenile records. So these are actually spaces where the Victim Rights Act provides a requirement that if a victim wants to address the court and make a statement on any of these issues, they have the right to do that. And this is one of the key things that allows victims to have increased participation in the criminal justice system, and is vital to that core intent of the VRA to improve the participation and voice that victims have in the process. Under the VRA, if a victim is incarcerated through completely unrelated matters or for any reason, they do also still have the right to be heard, but they can only be heard via phone or a similar method. They don't have the right to come to court, be transferred from their facility, and be brought there. But the VRA does still apply to people who are incarcerated for any reason. If they're the named victim in a crime, they have all the same VRA rights that attach. Under PREA, there's no similar right to be heard once a report is made. So really the only place that a victim who is in a facility can be heard is during that initial report, and then they might have no other information, no other follow-up. If there's follow-ups to the report, there might be more chance to share more information, but really anywhere else along the process until it's resolved, there's no other spaces for anyone to be heard from. There are safety and protection rights under both the Victim Rights Act and PREA. Under the VRA, there's that fundamental right, along with fairness, dignity, and respect, to be free from harassment and intimidation or abuse throughout the criminal process. And so that's a basic expectation, that someone that is a victim of a crime under the VRA shouldn't then be subject to more intimidation or harassment or abuse as a result of reporting the crime, having been a victim of a crime, having it reported against them, things like that, or on their behalf, I should say. There's specific rights, as we talked about before, around knowing the location of an offender, specifically for safety. So if someone has been released from jail or is out of custody or has been released from prison, probation or parole, there's obligations and rights for victims to know the location of the offender to ensure that they can better safety plan for their own protection. There's also a right under the Victim Rights Act that if there's a mandatory protection order issued in a criminal case, the victim has to be informed of that. If they are now subject or protected by a protection order, they need to know that and get a copy of that. And also a right to be provided with information about other protection services, address confidentiality program, other things that might be used to ensure their safety and protection, availability of witness protection in some jurisdictions, and what to do if there is any harassment or intimidation that they experience by an offender or anyone else related to the offender. There's also a basic safety right under the VRA to, when present at court, have a safe and secure waiting area separate from where an offender might be, where it's practicable. So not all jurisdictions have courthouses or space that there's a way to accommodate that, but it is a clear intent and right under the VRA that if possible to have a secure place for victims to wait in a courthouse. That is one of the rights that's provided. And then, as we talked before, under privacy, a lot of protection of location information. So there's no obligation for a victim to ever provide current address, current place of employment, and things like that that could be locating information. So a whole different set of safety rights that are in place under the Victim Rights Act. PREA, on the other hand, as we have talked about extensively, there's that strong prevention focus. So looking specifically at safety rights and protection from that prevention standpoint of how do you actually try and make sure a crime never occurs rather than trying to protect someone after it occurs. Under PREA, there's some very specific screening measures that are required of new inmates and in any time someone is transferred into a facility, and specific screening measures of staff. So anytime an inmate is processed into a facility, whether they've been identified as a victim of crime or not, they are screened for risk of victimization and risk of perpetration. And so there's a whole list of factors that are looked at that are based in evidence and research around these are factors that correctional staff will look for. And if they think that someone is more likely to be a victim of crime, they need to take measures to try and keep someone safer. What they can't do is put someone who might become a victim of a crime in isolation and administrative segregation unless there's absolutely no other option to keep someone safe. And then even if that is the only other option, they still have to have access to all programming and services and other things inside the facility, even if they're being held separately for their own safety. There is also a similar process for screening staff and very specific requirements that staff in correctional facilities can't have prior convictions or complaints related to sexual assault and sexual abuse. So it's recognizing that we know a lot of people who are victimized in facilities and in prisons and jails that is done by staff members, and so acknowledging that the additional screening of staff is an important preventative and safety factor that is considered under PREA. There are also, as I'd mentioned before, some protections against retaliation. So if someone has made a report under PREA for themselves or for someone else, there's very specific timelines and duties and obligations of staff members in facilities to monitor for retaliation, to make sure that someone isn't being exposed to possible retaliation. Might involve transferring someone to a different unit, things like that. As I'd mentioned before, part of those factors do not include maintaining the confidentiality of information, which is definitely a gap that we've identified, but there are specific recognition of the fact that there there could be more vulnerability to additional victimization after a report is made, and making sure that steps are made to try and prevent that. So moving on from the sections and the analysis of the differences in some of those key subjects and areas of the VRA and PREA, we're going to talk a little bit about what parts of the VRA and PREA are in harmony. So one of the key things is this underlying philosophical belief that people shouldn't be subject to victimization, that people shouldn't be sexually assaulted or sexually abused no matter where they are. It shouldn't happen in the community, it shouldn't happen in custody, and that inherent recognition of the dignity and that basic human right to not be a crime victim. There's also that philosophical idea that there should be some fairness and equity in the criminal justice system, specifically that punishment of people who have committed crimes shouldn't be cruel and unusual, and that very key piece of that just because someone has committed a crime doesn't mean they should also then become a victim of crime. So the VRA and PREA have that shared underlying philosophical basis around just generally the recognition that victimization is bad and hopefully shouldn't happen and should be prevented in any way possible. There are also some shared goals and some overlap in rights, but definitely more shared goals around safety, some shared goals around privacy, around at least a recognition of needing to access, as confidential as possible services, knowing how to make a PREA report, having some safety measures, whether it's after a crime has occurred under the VRA, or retaliation prevention under PREA, or just that preventative safety screening that's done under PREA. So there is that shared recognition that there are concerns for victims of crime around safety and privacy, and some around notification. Another area where there's harmony between these two laws is that there are no clear conflicts of law. So it's possible for any government entity with obligations under PREA to also comply with the Victim Rights Act, and vice versa. So if someone is a victim of crime in a facility that's protected under PREA, they have all their rights and obligations and processes and procedures under PREA. But if that also becomes something that's charged criminally, they also can have all their rights and obligations under the Victim Rights Act. So there's no conflict between the two different laws. Both of the laws also impose obligations on governmental entities, as we talked about early on. So the VRA creates specific requirements for law enforcement, district attorneys, courts, and then post-sentencing probation, parole, corrections as to victims of crime. PREA applies to the facilities where inmates are held, and we talked about that long list of different facilities before, and there's an obligation by all of those actors, who are all governmental actors, to comply with the laws, and those PREA and the VRA both specifically are the sources of that obligation. The other base thing I always want to make sure to circle back to and remind people of is that the Victim Rights Act and PREA both apply specifically to the criminal justice system. So there are no VRA rights in civil legal proceedings, in Title IX proceedings, things like that. It's specific to the criminal justice system. PREA also, by default, because it involves people who have been incarcerated, is also part of the criminal justice system. And I always want to remind people that even though these are two separate areas of law, if a person who's in custody is harmed and becomes a victim of a crime and a criminal case is filed, the VRA does still apply. So that goes back to that conflict of law piece. We absolutely know that the VRA provides for the same notice, safety, and other procedures, a little bit different around the right to be heard, but there is that right to participate by phone or a similar manner where there's rights under the VRA to be heard and be present in court. Along the way, we've talked a little bit about some of the gaps that we've identified in our analysis between the Victim Rights Act and PREA. One of the key ones that we point to is that there is no right to be treated with dignity, fairness, and respect under PREA. And unlike the VRA that has that fundamental recognition of it's not just preventing crimes and that basic human right not to be victimized, but further to actually, throughout the process, to be treated respectfully with dignity and in a fair manner. So that's something that is not currently in place in PREA. There are also minimal rights to privacy under PREA, which could have a very specific chilling effect on reporting, protective factors around if people know who reported, what they reported on, and there's no obligations to keep things confidential in the same way that there might be in the criminal justice system. Does that have an impact on reporting and outcomes on investigations? Another gap that we talked through some is there's very limited rights to notice under PREA, specifically just that outcome finding, and then some attempt to keep people updated on location of the perpetrator, which is in direct contrast to the Victim Rights Act, where there's increased participation across the entire criminal justice system for people who are named victims in those cases. So that is a big disparity between the treatment of victims who are incarcerated. The right to be heard, we've talked about a little bit too. If there is a separate criminal case, the VRA does still apply, and there is still a right to be heard on things. But if everything's handled administratively in-house in a facility, the right to be heard only applies as to the right to make a report about what happened. We also talked about the gaps between preventative and responsive safety rights. What PREA does that the VRA does not do is have this really strong focus on crime prevention. And that is one area where they have really excelled in trying to use research and studies and analysis to create processes for screening, ways to manage retaliation, different very specific things to try and make sure a crime never occurs. There's nothing in the VRA that specifically addresses the prevention of crime. And then one of the biggest gaps that we're going to talk a little bit more about is that if a PREA report is made and it is all handled internally in a facility and through an administrative process and no criminal cases ever filed, then there's no VRA rights or similar rights to the VRA that are provided. So whether or not someone has all those different rights around privacy and safety and notice, the right to be heard and the right to be treated with fairness, dignity, and respect can depend entirely on whether or not their victimization is also charged as a criminal case. Talking a little bit more about this, through the administrative proceedings in PREA, as we talked about, there aren't those additional safeguards or rights that a victim would have if the case was also criminally charged. And when we in our office through our analysis also looked at a review of administrative regulations, didn't find any rights that were even similar in the process of an investigation internally to a facility that are similar to the VRA. So no right to address any kind of hearing panel, no right to notice about what's going on, no right to be present and observe things, not the same kind of safety and privacy rights that we know are in place in the VRA. There is one provision in the Colorado Department of Corrections Penal Discipline Code that allows offender witnesses to refuse to appear, which is somewhat potentially of a safety right, privacy right, and this presumably should extend to victims, but there really is no other reference to any policies related to incarcerated victims in the entire Penal Discipline Code. So noting again, this leaves this sizable gap that we've identified, that if someone is a victim of crime and they're incarcerated and it occurs in a facility, if no criminal case is filed, they are deprived of access to all the same rights that are provided under the Victim Rights Act. Stemming from this and the analysis we did of these legal systems and the different gaps in the law, we've identified some areas for further investigation or study. So I'll go through each of these. One thing is trying to get more information about what kinds of cases are handled through just an administrative process, what kinds of cases are actually also charged criminally, so VRA rights would attach, and what does that actually look like in effect? Is there a difference in the type of cases, type of offense? Is there a reason why those cases aren't charged criminally? What makes sense internally for facilities and everyone involved in the process, getting stakeholder input of what process works better. Is there benefits to an administrative process and things like that? So additional research on that fact alone is important. Also getting input about how the VRA and PREA are currently meeting the needs of offenders and people who are incarcerated, and how it could be improved, and what impact the lack of having all those VRA rights on privacy, safety, participation, notice, the right to be heard, things like that, are having on reporting. Is there any impact on a reduction of reporting under PREA because those other rights are not in place? Part of this is also getting stakeholder input from advocates and employees who work with victims of crime who are incarcerated on how PREA and the VRA work in practice. And spinning off that also, what does VRA compliance look like for incarcerated victims? So we know there's obligations under the VRA that are still in place if someone is incarcerated. Does that notice still happen? Or do people still have the opportunity to be present by phone, to be heard on issues by phone? And how is the VRA compliance and rights actually being enacted in real life in facilities across Colorado right now? And then lastly, looking at whether or not in practice victims' rights are being honored in administrative processes. Is it possible that there are just some general practices and culture of investigation processes that do build in some safety, privacy, additional notifications, things that are not necessarily required under PREA, but might just be being done in some or all facilities across Colorado? As we just talked about, there's a lot of room for additional studies and additional things we'd like more information on spinning off of this analysis of the law itself. And that is our first recommendation, is to do additional studies on those factors from the prior slide. And then also to develop strategies to expand the rights of incarcerated victims based on those studies, based on the information we know about what's actually happening in practice, what exists in the law, and things like that. And then also looking at ways that we might be able to incorporate some of the basic VRA rights into PREA regulations or local DOC policies. So PREA is a federal law, so not necessarily incorporating those rights into the federal statute, but is there parallel Colorado laws that could be put in place, or regulations and policies that incorporate some of those additional safety protections, rights to be treated with fairness, dignity, and respect, notice, additional things like that that might be a good fit for the protection of victims who are incarcerated. And similarly, looking to extend VRA rights to victimization-related administrative proceedings. So if someone is going through a pre-administrative process, that is still part of the criminal justice process, and the VRA provides rights throughout the criminal justice process. So does it make sense to extend VRA rights to make sure that there are more of those protections in place, even if a criminal case isn't filed, because correctional facilities are inherently part of those that are subject to VRA obligations. All of these things are consistent with the purpose of both the VRA and PREA, of preventing crime, ensuring that people are treated with fairness, dignity, and respect, ensuring some level of safety and protection, and that core recognition, again, of the right to not be subject to victimization. So any of these recommendations and things that might come out of additional study would be consistent with both of these statutes. That's it for us today. I thank you very much for your participation and learning along with us on this process. If you'd like to contact Rocky Mountain Victim Law Center, this is our contact information on this final slide, and we would be happy to talk through any of these issues or anything else that we might be able to help with. Thank you very much.